Hi, and welcome to Financial Foundations. I'm with Elian Levatino, CFP, partner and advisor at Benchmark. And my name is Shannon Acosta, a CFP and advisor at Benchmark also. If you are new here, we are Benchmark Wealth Management, and every month we put out a video on a different topic of personal finance. And today we are going to go over estate planning. Some of you are here because you already have an estate plan in place, but you are so detailed that you want to make sure that all of your I's are dotted and all of your T's are crossed. Some of you are here because you haven't had an estate plan in place, either because you haven't gotten around to making one or you don't think that you need one. Well, for the extreme detail-oriented ones out there, do not fear. Following this shorter, truncated overview of estate planning, we're going to have a slightly longer deep dive on some of the topics that we're covering here. So stick around for part 2 if you are into the details. If you are with us in the room today, then statistically speaking, probably only 4 of us out of every 10 have an estate plan in place. And there are a few main reasons why. The biggest one is probably because you don't know where to start. There's a lot of mystery surrounding all of this. Second is that we tend to want to avoid thoughts about our own mortality and the human population in general. And when you're planning for an estate, you have to think very long and hard about your death. Third, in Charles Hummel in his book Priorities writes about the tyranny of the urgent. There's a regular tension between things that are urgent but not important and things that are very important but not urgent. Unfortunately, oftentimes, the urgent things get our time and attention. And your death, that hopefully isn't going to occur for many, many, many years, falls in the category of the very important but not very urgent. Estate planning sometimes gets the reputation of being too expensive. And then finally, a lot of you might not think that estate planning applies to you. And you're probably not wrong about any of those assumptions or any of those reasons if you fall into one of those 5 categories. Our goal today isn't to change your mind, but it's to give you another perspective that might convince you that you do need some type of estate planning. So if you have a plan in place, we want to affirm you, and we want to offer you information on the details to see if you do indeed have all of your I's dotted and your T's crossed. If you don't have a plan in place, we want to provoke you to new thoughts, some hard thoughts, and we want to convince you that you do need an estate plan. So bear with us for the next 10 or so minutes. Well, we're going to go through the overview, and I'll turn it over to Elian for what kind of plans you need to make for your estate. What's the purpose? Why should we do this?
Great introduction, Shannon. Thank you. That was fantastic information. Thanks everybody for joining us for this part of estate planning. I want to pass along my appreciation as well. Again, this is a quick overview. This will be a much shorter video, and we'll get into the weeds in the next video. But in a zoomed out approach, let's just start with what is your estate. It's really anything you own and even anything you owe. Not all of your debts go away when you pass away. And I know this is kind of a morbid topic, but you have to really consider ownership, what you own today, what you own jointly with other people, whether it be a spouse or a parent or a child, whatever that is. Not to mention things you've co-signed on. Those debts carry forward through to your estate. Not all debts carry forward through to your estate, but most will. And a lot of it's going to depend on state law and that kind of thing. So those are things you need to think about and consider when you're planning out your estate. But your assets, we kind of tend to use cash or investments or that kind of thing as a default. But the reality is, your estate can be not only investments and checking and savings and cash, but it could also include your home, jewelry, cars, any other kind of personal property, second homes, all that kind of stuff. All that is involved in your estate. Vacant land, 401ks, all those things, all that is included in your estate. So when you're piecing all this together, you're just gonna line all these up and say, okay, this is everything I have as an asset. This is everything I have as a liability. And this whole process is about arranging things while you're alive, so that when it transfers to whoever your beneficiaries are going to be, it makes things a little bit easier. If you've ever had to be the executor or executrix of an estate or even a trustee, you know that this can be incredibly complicated. So arranging all this while you're living just makes things a whole lot easier on everybody else. And there are a bunch of different goals that I'll get into for planning out your estate. You know, some of it is pre-death goals and post-date goals or post-death goals. But just number one is creating provisions that allow trusted family and friends to have control of your assets. So the worst possible thing is having accounts or having cash stuffed under your mattress and nobody knows about it. We've all heard of people that go into their grandparents' attic and find gold coins that were sitting up there that nobody knew about. You know, being able to pass along a list of everything that you have so that everything is easy to find, including all of your estate documents. When you create all of your estate documents, you want everybody to know where they are and where to find them. Because if you go to try to sell an estate without those documents, even though you've created them for your next of kin or beneficiaries, or whoever it is that's going to help clear your estate, if they can't find those documents, it didn't turn out to be all that helpful. Not to mention having a peace of mind and knowing that you have a say in what happens. If you pass away without a will, now you're going to let the government dictate and whatever precedent has been set on where your assets go and which hands it goes into. Being able to dictate that and make that your decision is incredibly helpful. And last but not least, protecting your family, protecting your children by predetermining their guardianship, their financial care, protecting your family members from other family members. Sometimes there's infighting of what happens to your estate if you pass away, and you have siblings fighting or parents fighting or in-laws fighting of what goes where. By having all this on paper, on purpose, you're creating this plan and protecting everybody on the back end of that. We find that incredibly important. Not to mention, I know it's time consuming, I know it's expensive, I know it can be stressful, but I think your family will thank you for putting all this in place and having all this direction. So who needs versions of estate planning? We're going to argue that anybody over the age of 18 or anybody with any kind of complexity. Obviously, the complexity increases as you age, but even an 18-year-old has assets, whether it be savings accounts, checking accounts, they have a job, they may even have jumped into a 401k. Having plans for all these things is incredibly helpful, even at that early age. But just because you don't have a lot of money to your name doesn't mean you don't need a plan. If you want to keep this on, if you're 18 and you want to keep this on the back burner and wait till you graduate from college, we're not going to argue too hard about it. But turning 18 sometimes is a rite of passage into an adulthood in different places in your life. And part of adulthood is having a will. Having all your belongings, knowing where your belongings would go, even your pet, who's going to take care of your dog if you pass away. Just some very simple estate planning things for someone who's that young. Your estate lives on when you pass away. There's things that need to be done, creating wills, creating powers of attorney, living wills. All these things are going to help everybody, all of your family, and everybody that's going to sell your estate down the road. Quite often, facts and circumstances change over time, and a person with no assets today may have assets tomorrow. So while a will lives on and your estate lives on, the will is going to dictate all of those things, even as they change. You're going to need to have them up. You need to have your will updated every now and then. But similarly, when a will is created in young lives as a young person, as they age, unless a new will is executed, that will creates certainty and guidance for what happens in the future. Again, if that needs to be updated, replaced, we're going to highly encourage that along the way. But as life changes, as there's significant life events, we're going to encourage you to revisit your estate planning, because usually with age comes a little bit of increased complexity. Shannon, why don't you take the next one? I touched on these a little bit, but there are a bunch of documents we need to put in place for estate planning. What are those?
Sure, and Elliot, that was a really great explanation of why you need an estate. And I'm hoping, kind of low-key, that put the fear into some of you, those reasons and explanation who might not have a will. Maybe you're a little bit more incentivized, or you feel some of the urgency after hearing why it's so important. Now, we want you to consult an attorney, but generally there are 5 main documents that you need to have in place for your estate plan. Elian talked about a will, and we'll go into more detail about this in the next video for those of you who are interested. But a will is the foundation of your estate plan. And without a trust or without anything else more complex, it could be the only thing you need to carry instructions on after you pass away. By the way, it's also the only legal document that can give instructions on how to handle children or pets or any dependents. So if you need somebody if you need to provide for your kids or provide guardianship or financial trustees for them, you're going to want to dictate that in your will specifically. A living will is the second document you want to have. This has absolutely nothing to do with the first will I talked about, which is known as a last will and testament. Your living will talks about which important healthcare decisions you have predetermined, even when you're not capable of communicating those to the doctor or the people who are in charge of your medical care. This is typically known as the pull the plug document. It has nothing to do with the last will and testament, but it's going to alleviate some tension and decision making from your loved ones if you have it in place. No matter where you are, in what phase of life, you need a will, you need a living will. Of course, only if you're over 18, as Ellian mentioned earlier. We've all been in the car with that person. You ask them where they want to go to dinner and they say, well, I don't know, you decide. And if you can't imagine being that person, then you probably are that person. I am that person. It infuriates my husband. I never want to decide where we're going to eat for dinner. What I'm doing really is selfish. I don't want to think. I don't want to choose. You choose. You deal with the consequences if we go there and we don't like it. I don't want that to be on me. And when you're not, without having a will or a living will in place, you're essentially asking the people you love to decide where you want to go to dinner, even when you might actually have some input that'll affect the rest of your evening. So think through that. And really, it's not so much about you as it is about the people that you love. You might need a third document called a general power of attorney. And this is where you give somebody legal agency to act on your behalf. It's general permissions. It might be if you're going out of the country and you need help handling things while you're gone. It might be if you're in a really busy, hectic season of life and you've got business decisions to make that you want somebody else to be in charge of. A fourth document is a financial power of attorney. This is specific. This is like a power of attorney, the general one, but it's specific to financial affairs, meaning that nobody can make medical choices for you or other legal choices. It's only what you want to happen with your money. A medical power of attorney, on the other hand, is limited specifically to medical decisions. Now, any of those three power of attorneys, whether it's the general umbrella or their specific powers associated, they can be either springing or they go into effect upon a specific occasion. Now, that's usually when you're incapacitated and a doctor will have to sign off on that, or they can go into effect when you actually sign the document. Oftentimes, spouses will have general power of attorney for one another that's effect when you sign the document. For some, a trust might be a sixth legal document that could you could bear to have in place. And again, we're going to refer you back to your attorney for confirmation of this. You might need a trust if you have a very sizable estate, if you own property in more than one state, if you want to keep your affairs private, and we'll explain more about that in a little bit. If you have really complex wishes that could evolve after you die, if you want to protect your heirs from future divorces or spendaholic tendencies, if you've had more than one marriage with children for multiple marriages or just one, a trust is not a tax dodge, and it is more expensive than a traditional will. Consider that when you're thinking through whether that's right for you. But again, your attorney can tell you whether or not that could be a powerful tool for your plan. Elian, we've harped on the importance of getting a will before you pass away. So what happens if you don't?
Yeah, if you don't take our advice, if we haven't been clear, we think you should get a will. I hope for the last few minutes you know where we're coming from. But if you decide, what's the worst that can happen? Well, kind of the way I tick is I'm a little bit of a control freak, and I like to be able to say what goes where. And if you know me at all, you know that to be true. But if you don't have a will, you're leaving a lot of these decisions up to other people. Even worse, leaving it up to a judge to make that decision. And again, I alluded to it earlier. There are some some precedent of what happens to things, to your possessions, to people in your life when you pass away without a will. If you pass away without a will, it's called dying intestate. And then the process for that is kind of a bunch of if-then statements. If you're single with no children, your parents inherit the entire estate, then siblings, then nieces and nephews, then relatives and parents, and the splits are different depending on who's going to get what. If you're married, generally your spouse or a combination of the spouse and your parents. If you have children from a different spouse or partner, they're factored into the equation too. If you need a will, but if you have a blended family where you're bringing children in each side is bringing children into the marriage, that just adds to the complexity. You absolutely need to have a will at the moment of marriage so that everybody knows how children are being handled and how assets are being handled amongst that blended family. That is so incredibly important. If you're unmarried, but you're living together, the surviving partner is not going to get anything unless there is a will. There's precedent for that. Please be very, very careful about those types of things. If you're married and you leave minor children behind, the state is going to decide who has custody of your children and will manage their inheritance before they reach the age of 18. Don't let the state dictate who's going to take care of your children. You want to make that choice while you're alive. Please don't leave that decision up to them. And not to mention any fighting that could occur between children, spouses, ex-spouses, siblings due to any kind of ambiguity. You know, we like to think that wills are going to scratch all the itches, but you know, sometimes there's things that are missing out of there, and there's going to be some fighting. The more you're able to put on paper, the less ambiguity there's going to be, the less family fighting there's going to be. We find all that to be incredibly important. So not that we want to scare you into doing this, but we kind of want to scare you into doing this. This is a really big deal to make sure people are taken care of if something happens to you, not just your assets, but the people in your life. I alluded to it very, very quickly when I talked about judges, but the whole process is called probate, and probate goes through these judges. Shannon, why don't you talk a little bit about what probate is and the parties involved in that?
Sure. And I want to echo Ellie in that we do love you and we're not necessarily trying to scare you, but hopefully we have put the fear of God in you just a little bit when it comes to having these very important documents in place. Now, that is the ultimate that we want you to consider. Make sure you at least have a will, at least have an estate in place. If you want to go one level deeper, we can talk about how to avoid probate within your estate plan in order to simplify things and fine-tune them even more. And I'll explain why that's important after I explain what probate is. Probate is a legal process of distributing your property after you die. Now, it's going to happen whether or not you have a will. So if we haven't mentioned it before, I'm not quite sure if we repeated ourselves on this matter yet or not, but you should have a will. Even if you don't, you're going to go through probate. So anyway, probate is when your will or your estate goes before a judge. Your executor, if you have a will initiate the probate, and the court is going to validate it. They're going to say, yes, we agree with what was written in this estate, and then the judge authorizes the executor to distribute your estate to the beneficiaries that you've laid out. Your executor is also authorized to pay taxes that your estate might owe, and to file your final tax return. The laws and the process for probate vary by state. Sometimes they're more complicated than others. Sometimes you need an attorney to represent you, and sometimes you don't. You need to look at the laws and where you live and ultimately consult an attorney. Why do you want to avoid probate? We're not going to talk about how just yet, but why? Well, it can be slow. It can take sometimes more than a year for the judge to go through everything and decide ultimate validity and to give ultimate authority to the executor to distribute things to your heirs. So if you want your children to wake up the day after you go to heaven and have everything accessible to them, a will, passing everything strictly through a will and having to go through probate is going to disappoint you just a little bit on that matter. Probate can be expensive, there's court costs, and it's public. Anytime you go before a judge, that's public record. So if anybody really wanted to know what you own and who you dish it out to, they can find out. All right, if you've made it to the end, we are wrapping up the first overview session on estate planning, why it's important, whether or not you should get a will, and if, do you think you should get a will? Have we answered that question yet?
Shannon, I think they should get a will. I think that might be something important.
Okay, good. Get a will, people. And if you want to know the details on what's in a will, and if you want to know the details on all of the financial documents that we talked about a minute ago, how to avoid probate, if you're interested in doing that, then stick around for the more detail-oriented one that we're going to nerd out a little bit on after this video. Please reach out to Elian or to me or anybody else in the Benchmark team if you have questions on anything that we just covered. And of course, your attorney, who will be your estate plan cruise captain, director, making sure that everything is the way that it should be. Thank you very much, and we'll see you again for the estate planning part 2 or for next month's financial foundations.
Thanks, everybody. Bye.